morning, everybody. Welcome to the City of Columbia Municipal Court. We are here in the matter of the state of South Carolina versus Alexander Dickey. Is Mr. Dickey in the courtroom? Good morning, Mr. Dickey.
How you doing, sir?
Good. Mr. Dickey, you are charged in the Court of General Sessions here in Richland County on the charge of murder, burglary first, 2 counts, possession of a weapon during the commission of a violent crime, 2 counts, grand larceny, 3 counts, financial transaction card theft, 3 counts, and possession of a firearm by a convicted felon. So that's a total of 12 warrants. In sequence, they are 2025-0402, 160-1544 through 1555. Under our United States Constitution, our South Carolina Constitution, and South Carolina state law, any time a person is arrested and charged with any criminal offense, they have a right to come before a judge to determine their eligibility for release while the case is pending trial. It is commonly known as bond setting. In this case, as you've heard, one of the warrants you are faced with is for murder, and under South Carolina Code of Law, section 17-25-45, murder is an offense that carries as much as life in prison. And because of that, South Carolina law requires that your bond on that warrant be set in the Court of General Sessions. It is also my understanding that you are being held in Lexington County without bond. So today will act as a de facto arraignment in that I will not set bond on any of these charges. They will all be sent to the Richland County Court of General Sessions to be set by a circuit court judge.
Yes, sir.
Now, when your case does go to trial, you have both the right and the obligation to be present in court anytime this case is called for any hearing. If you are not present when the case is called, a bench warrant will be issued for your arrest if you are out on bond.
Yes,
and when
sir.
that bench warrant is served on you, you will be brought back to the jail and remain in the jail until these charges are disposed of. Also, by failing to appear, you may have forfeited any bond that you post in order to be bonded out, if you are able to bond out. And you could face an additional criminal charge for failure to appear in court.
Yes, sir.
You do have a right to an attorney. If you cannot afford one, one can and will be appointed to represent you. You'll be provided the application for court-appointed counsel, and if you fill it out, the court will consider your application for court-appointed counsel a public defender. You also have the right to represent yourself without an attorney. It is my legal duty, however, to inform you that self-representation, proceeding without an attorney at your next court date or any other court date, can be very dangerous. Criminal defense is a highly technical and specialized area of the law, so there can be certain factual, legal, or other types of defenses to the charges you're facing that if you choose to proceed without an attorney, you may not be aware of. There could be issues related to the conduct of a guilty plea or a trial that could arise in the future that you might not be aware of, and it will be your attorney's responsibility to make you aware of any and all issues and how to properly address those issues before the court, and if necessary, preserve those issues on appeal. There could be collateral consequences to a conviction that you're not aware of, including but not limited to an increased penalty for any subsequent offenses, the suspension of your driver's license, the restriction of your right to possess firearms or ammunition, or your immigration status could be affected. So if you do choose at your next court date or any other court date to proceed without an attorney, understanding that you yourself will be responsible for complying with all the applicable rules of court, including rules of evidence, procedural rules, and proper behavior before a judge and/or a jury. Understand you do have a right to a jury trial to dispose of these charges. In the Court of General Sessions, you are presumed to be requesting a jury trial until and unless you formally waive that jury trial right on the record in court. You have a right to a preliminary hearing. Preliminary hearing is a probable cause hearing. You must make that request for the preliminary hearing within 10 days of the bond setting that will occur in the Court of General Sessions. Mr. Dickey, do you have any questions about anything I have told you here this morning?
No, sir.
All right, thank you very much. This court is adjourned.
This concludes our bond court docket. The time is now 11:35 a.m.